starting with, as I briefly stated, so we have prepared an index, which would be so this part may be a little bit lagging, but it's very important to understand that what exactly is the term greenwashing is, whether greenwashing is the original term or something else. So the origin of the term, the evolution of how greenwashing has come to be, and where exactly India stands as on this date, the types of the greenwashing which are prevalent, so that people and especially advertising agencies, they are aware that what exactly are the different kinds of greenwashing tactics that are being used by the conglomerates in their advertisements. So for that, types of greenwashing, the growing concerns over the issue of greenwashing, the background of the guidelines, a little bit of the glimpse of the guidelines, blueprint, what exactly do we mean by evidence? So when people say that, okay, greenwashing, what do you have as a credible evidence to back it up with? So what exactly are the prevailing standards for evidence? Are there any other statutes apart from the current guidelines that we're going to talk about, the nodal agencies, redressal forms, the kind of penalties if somebody is contravening the present guidelines, or for that matter, any of the other existing statutes, precedent so far, and probable criticism surrounding the present guidelines as well as how it has been tackled thus far. So to begin with, what exactly is the term of greenwashing? So greenwashing, only when it comes to the environmental claims, the term is greenwashing. Otherwise, what we refer to commonly as whitewashing is something to mean that if there is an unsubstantiated or a deceptive claim to somebody about any product or any service or any brand. So as and when it impacts on an environmental claim, it is highlighting to be environmental friendly, but whether it is actually or not, the broad term has been defined as greenwashing, and it was coined by J. Westerfeld in the 1986. So prior to 1986, there was no acceptable definition of greenwashing. There were several, you would have seen various old ads, and we would like to play an advertisement as well, that talk about the benefits of what is a nuclear energy. This is the cleanest form of energy. So this is a pre-1980 stage. By the time 1986 rolled out, and this was also because, very interestingly, there was a so you might, we all have visited several hotels. So towels are being reutilized, and it was campaigned that reutilizing of the towels is environment friendly. But the main goal behind stating that was not environment friendly, but was a cost-effective mechanism by that particular hotel to save their costs on their overheads, but it was not exactly proven that this is environmental friendly. So this is the term, when you're whitewashing the consumer to and duping them to believe something to be environmental friendly without backing it up with a credible evidence. That is what the broad term of greenwashing is, and it was coined by J. Westerfeld in 1980. After that, since then, there have been various guidelines, including the Green Deposits Guideline of 2023 by the RBI. We also had the SEBI coming up with the Green Deposit Securities of 2023. But what they by and large did was they only gave a definition of greenwashing. There has been till date, before the ASCI coming up with the standards in 2024, followed by the current guideline, which is the subject matter of our presentation today, which is the Prevention and Regulation of Greenwashing or Misleading Environmental Claims Guidelines of 2024. Was there ever any different enactment that would be that would act as a stopgap behind all these ethical, behind the actual how ethical guideline is supposed to be? Sorry. Okay, behind how ethical guidelines are supposed to be when it comes to environmental protection, or what are the possible penalties, what are the possible contraventions, whether there are any declarations that one has to submit. So till the ASCI came out in 2024, after the CCPA came down very heavily, which is the Consumer Central Portal Protection Authority, until they came down heavily, there was no such particular guideline. Before this, globally, we also have the European Union's Green Claims. We have the US Federal Trade Commission's Green Guides. We have the Green Claims Code and the Consumer Protection for Unfair Trading Regulations of 2008, all of which are globally. But in India, we had a huge gap. When we talk about this gap, what exactly are the gap are we talking about? So for that, we need to understand first and foremost what are the various types of greenwashing. One would be an environmental imagery, one would be misleading labels, one would be a hidden trade-off, irrelevant claims, or lesser of the two evils. So what do we mean by environmental imageries? So for example, you would have seen that our first slide, if I may, talking about prevention and regulation of greenwashing or misleading environmental claims, and we put up an image of 100% sustainable, eco-sustainable, this imagery that we are trying to put up. This image has nothing to do with Hammurabi and Solomon. Are we an eco-sustainable law firm? Or so that is exactly the thing. We have something, we are giving an environmental image to build up something which has nothing to do with my motto, which has nothing to do with my services. Or I am providing a label, for example, Hammurabi and Solomon sustainable practices. What do we mean by sustainable practice? Sustainable in terms of environment has a far-reaching impact. So these words like sustainable, eco-friendly, what is the credible backing up behind this? So we have covered environmental images, misleading labels, hidden trade-offs. While saying we have a sustainable practice, we are trying to pawn off the word sustainable practice in an environmental friendly. Do we represent environmental claims at all? So we are trying to piggyback ride on something or trading off on something which has a different connotation altogether. Thereafter, we always have irrelevant claims, and lesser of the two evils usually refers to such claims which may be true. There may be a potential behind the truth of something, but it is also a tactic to dupe the consumer from the greater environmental impact and just, highlighting my product. For example, children playing in the mud field, and Surf comes up with an ad, and Surf says XYZ, etc., 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 all of which are good. But at the end of the day, it also says that this is environment friendly. The moment we are hardwired to believe, because of the current scenario where we are currently living in, we are hardwired to believe that, okay, the moment this is environmental friendly, that word comes, maybe I will purchase this product over something else. But this thing that somebody is using only as a claim, is it backed up or not? There may be true. A certain product may be environmental friendly, but have they given their declarations for the same? So as such, is it only a tactic to remove the consumer's attention from something or not? So these are the various types of evils we deal with when it comes to greenwashing, which also, it's like a Venn diagram. So we have a lot of intermixing with ethical advertising standards as well. Greenwash ethical advertising in a broad spectrum may not necessarily be for everything related to environment. The purport of the guidelines presently and the current topic of our presentation is greenwashing, ethical advertising when it comes to environmental claims. So what have been India's efforts to regulate such greenwashing thus far? So thus far, as I started with, we had the green deposits enacted by the RBI and the Securities of Exchange Board, which came up with the definition of green deposit securities of 2023. I would not bore you with the exact wording of the definition, but the framework of RBI and SBI, they were related specifically to giving a definition to greenwashing, to the extent of stating that this is a deceptive or a misleading practice, and this is not there is no substantiated backing for it, or it is false, or it has a false environmental claim. But until and unless ASCII came into picture, and that too by a case that went up in Supreme Court in the Indian Medical Association versus Patanjali, which my colleague Pranshu would be explaining much better in the following details, in the following slides. ASCII was the first consolidated entity, the first regulator that came up with a set of guidelines, and that was the first guideline ever through which the claims which were greenwashing and which were not credible, they came under the radar of the CCPA for the first time. So ASCII in 2024 released their guidelines, post which they processed complaints against 116 advertisements which had all the potential violation of its various guidelines. And then the Central Consumer Protection Act, they intervened and released a statement stating that if ASCII's code and guidelines are violated, then you will be falling under the Section 2R of the Consumer Protection Act, which is unfair trade practices, and you would be liable. And that is why the 116 advertisements were processed. However, even thereafter, the growing concern with the greenwashing and the actionable claims are rising, and there was no mechanism, and the question was really asked that how do we back up our claim, and what exactly do you mean by a credible evidence? We have to realize that the purpose of coming up with the guideline was because of the gaps in the legislation, including even after ASCI's guidelines. And the gaps were these questions: what do you mean by credible evidence? What do you mean by I have to disclose? What do you mean by a third party? How do I disclose? So this is where the guidelines come into picture. So the guideline was the brainchild of Nidhi Khare, the Chief Commissioner of the Central Consumer Protection, who created this committee, and they came to address this issue. For the first time on the 20th of February of 2024, they roll out the guidelines to the public, and they come up with several feedback from stakeholders. So the key suggestions, as you would see on your screen, the environmental claims must be credible with certifications, reliable scientific data. So when we talk about scientific data, we mean the WHO certificate, or by the Drugs and Cosmetics Central Licensing Agencies, LNM certificates that most of us advise our clients and even otherwise that, okay, when you are putting out a label, is it an LN certified? Are you certified by the BIS? Is there an ISO certification? So these are things. So how do we put this across? That also has been dealt with in the guidelines. Adequate disclosures are essential for claims. Whenever some people use the word I am eco-sustainable, the words natural, the words organic, the words pure, these words have to be when companies are utilizing such words in their advertisements, these have to be backed with disclosures. Now, this disclosure is very important to understand. This also came up after the ASCI, and this is also after the Supreme Court's case in Patanjali, wherein they said that, okay, when you're using such word, you have to give a disclosure. And where this disclosure would come up to be, there are forms. These forms are called the SCTs. These forms are given by that governing particular agency. Terms like sustainable, natural require contestants to avoid misleading the consumer. So the goal ultimately is to stop the consumers from being whitewashed to buy something only because it is stated or purported to be eco-friendly, but there is no credible background for it. So the context and rationale, to succinctly put, is to address the issue of greenwashing and the rise in deceptive advertising, exploiting consumer consciousness. Key goals including fixing accountability, consumer protection, where consumers can rely on the environmental assertions. They have been introduced with the purpose of enhancing the credibility and the transparency of the environmental claims, and to avoid the unsubstantiated claims used by the corporations. We have to understand, really go into the depth of whether the corporations are utilizing it only as to make their company as a cost saving, or there is actual credibility and backing up to their claims of environmental protection. The guidelines also help address the increasing prevalence for the advertisements for green products and the growing environmental consciousness among consumers. And more importantly, it is very important to understand that these guidelines are a supplement. They are not to replace, and they are not the only ones. When we talk about supplementing, what do I actually mean? So when I said that the CCPA came down heavily, they came down heavily because if it is a misleading advertisement, then under the Consumer Protection Act, the company falls under something called the unfair trade practices, which is defined under the Consumer Protection Act. Afterwards, we also have the Central Consumer Protection Authority rules, which came out in 2022, which also prevent deceptive advertising. We thereafter have the ASCII standards. There are several acts. We have the FSSAI. We have the Drugs and Magic Remedies Objectionable Advertisements Act. We have the Legal Metrology Act. We have the Legal Metrology Packaged Commodities Rules. We have the Cable Television Rules, and we also have the COPTA, which is the Cigarettes Protection Act. So under all of these acts, the claims for misleading advertisements is already covered. This guideline acts as a supplement to all these acts. These guidelines act as a supplement to these acts from an environmental standpoint. So the objective of the guideline is to protect the consumer's interest by preventing the misleading claims. They help mandate evidence-backed environmental assertions, and they foster informed decision making and transparency. Now that we have understood the reason for the guidelines, we would like to visit what exactly the entire glimpse of the guidelines. So we have the definition of the advertisement agency. We have a proper definition to move forward with greenwashing. We have a proper definition to move forward with environmental claims. The scope of applicability, on which all entities is it applicable and where it is not applicable. What exactly is it, a mandate, or is it a maybe mandate? Is it a shall mandate? So hence the prohibition on the greenwashing. What exactly do we mean by substantiation of environmental claims? What are the mandate for adequate disclosures, and what exactly are the various kinds of other claims, whether it will be dealt with which nodal agency, if there is an ambiguity, what would be dealt with and not. So here I would like to take a pause and explain that greenwashing, although there have been prevalent definitions otherwise as well, greenwashing under this guideline means the deceptive practices that exaggerate or falsify environmental claims, excluding obvious hyperboles, puffery, and use of generic color schemes or pictures not amounting to any deceptive and misleading practice or general mission statements. So these are a lot of words. So how do we explain it much better? So on your screen, you would see an illustration. A detergent advertisement showcases a family happily playing in an open grass with the tagline, gentle on clothes, gentle on nature. They have not stated anything in their advertisement that says that this is environment friendly. Is the detergent being environmental friendly, the bottle being biodegradable? The words, they do not justify the advertisement. The words are not backed with any credible claim. This is a classic example of greenwashing. The advertisement that I was speaking of earlier was that of nuclear energy. Nuclear energy is the cleanest form of energy. But is it true? How do we know that it is the cleanest form? Because nuclear energy has several drawbacks. There is also solar energy, there is also wind energy. These are all cleanest forms. So when we use a comparative data, to what aspect are we comparing it with? Is it only when it comes to energy? Is it only when it comes to the disposal of the materials? Is it about the materials? So this behaves as a gray area in our minds, or in anybody's mind, that which part exactly is environmental friendly, and how it impacts the consumer is they see these words, they see the tagline, and they go ahead to purchase it. And there is no conceivable way for a consumer to be aware from a particular tagline whether the fact that they went for gentle on nature, whether it is true or not. So this is the definition of greenwashing that flows from the guideline, and this is exactly what we, through the guidelines, we see are being tackled. Advertisement agency means a person or an establishment providing services in designing and production of the advertisements. This is important as a definition to understand, is because under the guideline 3, the guidelines apply to advertisers as well. So as an advertising agency, whenever a manufacturer or a service provider or a trader or an endorsement agency, they come to such advertising agencies and advertisers and say, you promote my product, the advertising agencies are also liable under the guidelines to check that the product, if they are portraying something to be environmental friendly, is it backed with the certification? Is it backed with the is it a credible claim? Is it backed by enough information to prove or substantiate such claims? So that is very important for an advertising agency to understand on a broad scale before they promote something of somebody on their own letterhead or on their own platform. Non-applicability, the guidelines, they do not apply to any advertisements which is not specific to any product. So as long as it is, assuming it's a company in the gold marketing area which have used no words relating to environment, sustainable, cruelty free, anything, they have come up with that particular product, then that advertising agency related to that particular product is not liable, or not, these guidelines are not applicable on that advertising agency. Now we come to the prohibition against engaging in greenwashing. Any person who comes within the ambit of this guideline are prohibited from engaging in greenwashing practices. Are prohibited. This is a mandate. This is not directory. This is a mandatory provision. This is not something that one has an option to choose and not an option to not choose. This is something that is going to be heavily looked down, and the CCPA, which is the Central Consumer Protection Authority, which is also the nodal agency for the enforcement and the dealing with the complaints in such cases, will come down heavily if any of the people on whom it is applicable. Let me revise: the advertisers, manufacturers, service providers, traders, advertising agencies, and endorsers involved in promoting such claims. Any of these, they engage in anything remotely related to greenwashing practices, the guideline is going to be a mandatory thing. Substantiation of the environmental claims under Guideline 6. Environmental claims using generic words such as eco-friendly, green, shall not be without adequate disclosure and substantiation. So what do we mean by the adequate disclosure? If you are eco-friendly, there would be a WHO certification. Do you have that certification? Terms such as ecological footprint or greenhouse emissions, these are very heavy worded uh, heavy words. Not every consumer is aware of what exactly ecological footprint would mean. This has a less carbon footprint, this has a less ecological footprint. So these words are not consumer friendly to several blue collar working people. So as such, what exactly is the impact? Okay, this is lighter, this is soft touch. These are words which are much more consumer friendly. So as opposed to heavier words of ecological footprint, these words should be encouraged, and all claims must be backed by verifiable evidence. So when we talk about verifiable evidence, if it is a manufacturer or a service provider or a supplier, they will have the evidence, but who exactly is liable to check it? If they are going through a marketing agency, if they are going through an advertising agency, it is that advertising agency who has to check that whether these claims, otherwise the prohibition kick in under guideline 5, otherwise the applicability kicks in under the guideline number 3. When we talk about disclosure mandates, what is usually now recommended and which has also come down in these guidelines is to use QR codes. So when we see under the Legal Metrology Act, for example, for a water bottle, and I would give a live example. When we have a water bottle, Bisleri, for that matter, we have something which is a QR code here. So Amit, in this QR code, the certifications would be uploaded, or it could be as simple as www.bisleri.com. It's an URL. The consumer is enabled to click onto something or to scan something to go to a particular website and understand that, okay, this has this certification. And what is even more important as a disclosure mandate is to avoid selective or unfavorable data from being omitted. For example, if my Bisleri water has a fewer minerals, which there is a dicey understanding in the Scientology sector that this mineral may or may not be kosher for a human body system, then that should be there. It should be with an asterisk, that there should be a warning. Sometimes, if you would have seen in Diet Coke bottles, there is a disclaimer that it is unsafe for expecting or pregnant women. So these are good practices. So if it is actually unfavorable to a certain category, this should not be omitted. So this practice of omitting something just because there would be a lesser market sale, this is not right. This is when, so that is a that is a ethical advertising. If it says that this is not exactly good, so plastic bottle, the plastic bottle, until and unless you throw it into a reusable segment of the dustbin, it will have environmental impact. So this is a knowledge which is essential for the consumer to be aware of. So to avoid such unfavorable data, that is also part of the disclosure mandate on which the guidelines talk about. Now, which is very interesting, is a comparative claim. When we talk about Lysol is better than X, better than Y, better than Z, we just put it out. But what exactly, which aspect of it is better? Is it the aspect when it relates to a particular environmental hazard? Is it an aspect when it relates to a medical hazard? When we talk about this is a better compostable or a better better compostable product as opposed to product Y, That is important. We have to specify the aspect that, okay, when it comes to compostability, this product X is greater than product Y. So that we cannot have blanket statements that product X is better than product Y because of environmental challenges. How exactly is the environment affected or impacted or not impacted by product X but by product Y? That is very important to disclose. And when we disclose it, it has to be substantiated with credible evidence as well. Coming to the next one, the example of compostable, biodegradable, they require scientific proofs because these are heavy words. These are words that appeal to a consumer as well, and these are also scientific words that are given to a product after due examinations. Aspirational environmental claims can be made only if there is a clear, actionable plan to achieve them. So, if they say we are coming up with a any advertisement or any product or any service sector, they come up with a product that says that we will have solar energy going through an entire town in the next 5 years. There would be a URL which would give a data action plan that, okay, this is environmental friendly, this can be achieved, and hence there is a clear actionable plan to achieve. So the guidelines have literally gone into the minute possibilities of in all ways a product is marketed to the consumer. They have tried to envision every way, every check and balance that a service provider, a manufacturer, an advertising agency, an advertiser, or an endorsement agency would be able to verify and would be able to verify with credible data and evidence so as to actually put it out there. The guidelines are an additional layer to the existing laws that we have already stated, that there are different laws, and when there is a contradiction, let's say there is a contradiction between the guideline and the Consumer Protection Act, the statutory law will prevail. And who will decide the prevality of it? It is the Central Consumer Protection Authority, which will go before the NCDRC, depending on the valuation, which my colleague is going to cover. And all these contraventions will be addressed by the governing act, which is the Consumer Protection Act. It is very essential to understand that the guidelines today are a supplement to all the existing advertising, ethical advertising standards, which have been carved out time and time again under several various statutory laws. The guidelines are not in replacement of any of the existing laws. Now over to my colleague.
So good evening, everyone, again. And thank you, Mr. Yashodhara, for this insightful information on the guidelines. Allow me to take you through the second half of the presentation.
I am sorry, I think your voice is echoing, so I think can you
Yes.
please mute the other speaker if in the same room? Thank you.
Okay, so now I believe it's clear. Yeah. So Ms.
Yes.
Yashodhara has already given a brief background to the entire terminology of greenwashing and a detailed description about the current guideline of 2024. So this guideline ends with the guidance note in the form of an annexure, the one that is displayed on your screen, named under the blueprint of ethical advertising, actually deals with that annexure of the guideline. This is basically in addition to the already discussed topic, that is the adequate disclosures that are required. These blueprint is basically for the industry stakeholders to ensure that they comply with the legalities and the regulations. They have laid down 6 principles under which this adequate disclosure should be followed. So I would just take you through these principles. The very first was truthfulness and accuracy, as it has already been dealt by my colleague. Any claim, any environmental claim has to be supported by substantiated evidence, scientific evidence, certification, and accreditation. It has to be truthful and it has to be very specific, accurate, on the point, not to mislead the consumer therein. Second, if I can mention, the principle mentions about clarity and unambiguity. For example, the guidance note also gives various illustrations there. So I'll just take you through one or the two illustrations therein. Clarity and unambiguity, if some companies claiming like go green with a product. So there is a huge ambiguity there. go green as in what aspect, and how can someone presume that it's a green product, or the company is a company that is following the sustainable practice leading into environmental friendly practice? So that has to be specified there. The third principle is relevance and specificity. As I already mentioned, it has to be very specific, pinpoint. If we're mentioning a hand wash is biodegradable, what is biodegradable? The packet, the hand wash inside it, or the packaging that it is in. So consumers should not be kept in an illusion that the wrapping is a biodegradable, however the entire product is not environment friendly. Then the fourth principle there is fair and meaningful comparison. This has also been dealt by my colleague. However, I'll just give you a brief background to this also. If we're mentioning, or if a company or a corporation is making any comparison with a competitive product, so which section of that product is being compared to, which component of that service is being compared to, the entire manufacturing process or the disposal process, that has to be specified, and that has to be accessible to the consumers at the very tips of them. The fifth principle mentioned there is use of imagery without substantive claim. The use of generic themes are not included under this, like generic green color, generic schemes or theme or templates are not included. However, any such imagery with a disclaimer, like go green with the product and help the sustainable practice enhance. So how are you actually leading to that principle? How the company is actually looking into that and working towards that eco-friendly principles? The entire procedure of a company has to be explained there. The disclaimer cannot contradict what is being shown in the image. The last principle enumerated there is endorsements by the environmental organization. So the CCPA guideline has actually come down heavily upon the endorsers, the celebrities, the media houses. They have to be very much equipped and informed about what information they are imparting to the consumers, and these has to be supported by evidentiary backing. If some product mentions that it is certified by expert, certified by environmentalist, then provide the certification of that environmentalist. Now let's go back. Let's go next to the credible evidence context. The entire guideline has mentioned about reliable evidence, credible evidence. So what actually goes into and transpires to that terminology? We have this made the few distinctions to make it easy for the consumers and the industry stakeholders to understand. So different kinds of evidence is mentioned throughout the guideline is the third party certification. The guideline is also being appreciated because it has given a recognition to a third party certification, unlike the previous laws and the existing guidelines. So third party certification can be considered. Few of the examples are displayed on the screen, like Energy Star, the LEED certification, that is leadership in energy and environmental design. These are recognized and considered to be a reliable substantiation and qualifier for a product or a service. Then independent studies have also been given a recognition herein. Independent studies as in the recognized research institutions doing a survey based on stats and data of that particular area. Like if we are mentioning environmental impact assessment, so the impact assessment of a particular area, the data, that has to be presented to the consumers. It should be available either through the QR code or through the scanner, and it has to be there for the consumer, for the public out there to read and make their own informed decision. Third point, government or statutory certification. Statutory certifications are already existing there, like Bureau of Indian Standards. It is basically for the eco-label products, and then the FSSAI, that is the Food Safety and Standards Authority of India. These are related to the claims that a company or a corporation makes relating to a food product. So these has to be substantiated and provided to the consumers while advertising any product or service. Then lab testing or reports. Lab tests like mentioning cruelty free, mentioning chemical free, it has to be supported by a lab accreditation, a recognized accredited lab. The last one is the internal evidence. Internal evidence can be explained through an illustration. Like if we say a corporation is involved in an energy efficient manufacturing. So the entire process of that manufacturing, right from starting of the manufacturing process, the manner in which it is being manufactured and the manner in which it is being disposed, you have to provide the entire guideline and supporting while advertising your product in public. Now for the next slide, I'll just take you through the already existing statutes and guideline dealing with greenwashing and misleading environmental claims. I'll just run you through these because it's a huge legislation: the Consumer Protection Act, the Guideline for Misleading Advertisement 2022, and the ASCII guidelines, that is the Advertising Standard Council of India guidelines. So the Consumer Protection Act of 2019 is the already existing act herein. Yeah. So Section 2, Clause 28 defines the term misleading advertisement. This act does not deal specifically with greenwashing, which is the current relevant topic herein. However, it deals specifically with misleading advertisement. The components are more or less similar that has been covered and elucidated further in this 2024 guideline. Falsely describing the product or services, you are providing false guarantee and warranty to the consumers. You are representing and involving and engaging yourself in some unfair trade practices, and you are deliberately concealing the unfavorable part of a product or a service, and you are only portraying the favorable part of a product or a service. Few illustrations, if I can help you with, like a company mentions in a product it's CFC free product, but in totality CFC is actually banned under the law, but the consumers are unaware about it, and hence there comes the responsibility and obligations of the corporations, industry stakeholders. Another example, if I can say, like Green Seal, a company is it's advertising its Green Seal. However, that Green Seal is nowhere supported by any accreditation or regulatory body, is nowhere certified by any of the regulatory and statutory bodies. These are the checks and balances that these guidelines actually deals with. Now, second section, if I can say, it's Section 2, Clause 47. This mentions about unfair trade practice. I'll just take you through a few of the pointers that are mentioned therein. False claim, misrepresenting quality and standard of any good and product. Misleading representations, you are using false sponsorships, approvals, benefits, just as a deceptive practice for the consumers. Then there are invalid warranties that are actually not sustainable and they are unverified. So these are similar to that of the misleading guidelines that has been there in 2024. Section 10 further explains about the establishment of the central authority, that is the consumer that is the CCPA. So the establishment of CCPA is basically for addressing the violation of consumer rights, addressing unfair trade practice issues, and the misleading advertisement claim. This authority is composed of chief commissioners, and further it can be delegated to the district collectors under Section 16. Headquarters is in Delhi, and other branches can be there as determined by the Government of India. Further, Section 9 deals with the penalties and punishment for the misleading advertisement. It ranges between 2 to 5 years of imprisonment, and it ranges between 10 lakh to 50 lakh fine. And it depends on a first-time offender and a repeated offender. Now, let me take you through the guidelines for misleading advertisement of 2022. That was a predecessor to this current guidelines. Those guidelines nowhere mentioned with, nowhere dealt with the term greenwashing. However, they had dealt with the misleading disclaimers, they have dealt with misleading claims, and what all amounts to the valid advertisement. Applicability is same as that of 2024. All advertisers, manufacturers, traders whose products and services are dealing with advertisements, advertisement agencies, and endorsers are covered under this, same as the 2024 guideline. Then there are certain conditions for valid advertisement that has been enumerated in these 2022 guidelines. These have been further substantiated in 2024 guidelines. That is, it has been substantiated with adequate disclosure mandate, what comes under adequate disclosure mandate, what are the reliable evidences, as I already discussed about. Few of the valid points were truthfulness, substantiated claims has to be there. Then you have to comply with the already existing law, and material information has to be displayed in the product or the services so that the consumers can make an informed decision. Now they have dealt specifically with disclaimers, because basically when imagery is used for advertisement, they put in a very small, unreadable, in a complex legal terminology disclaimers that are actually not apprehended by the common masses, by the layman, if I can say, or by any person who is not in day-to-day functioning of a legal system. So these disclaimers have been given a quite a specific definition. It has to be a very clear, visible, a plain, simple language, and that disclaimer cannot contradict the one that you are making the main claim in. Now, let's move on to the ASCII guidelines of 2024 that has actually addressed the terminology greenwashing in addition to this current guideline of 2024 by CCPA. ASCII guideline also have mentioned few of the pointers as it's displayed in the screen. It has to be evidence-based claim. It has to be a holistic assessment. Holistic, if I can just give a few explanation to that, it has to be either the complete product or a service or any particular component of it that has to be clearly displayed and informed to the consumer. Specificity has to be there. Specific claim regarding component or entire product has to be there, whether a wrapper is a biodegradable or the product is a biodegradable. It's mandatory to display it and inform the customers. Then free of claim has to be avoided. Any competitive marketing that corporation deals into and making a comparison that it's free of chemical, it's free of CFC, that has to be avoided up to the extent it is possible. If not, kindly back it up with a substantiation. Then transparency in certification has to be there. It has to be evaluated by certification and certifying bodies that are recognized by law. Then responsible use of visual, as I already addressed, it's the same. Visual has to be there with a disclaimer. Disclaimer has to be in consonance with the visual, and it has to be plain, simple, very easy to comprehend by the common man. Carbon offset accuracy. I will just give you a brief background to the carbon offset. Carbon offset is a unit of measurement basically for the greenhouse gas emission, and certain standards are set up by the corporations while dealing with the carbon offset. Certain limit, a predetermined cap is also been imposed by the legal existing statutes. So the companies and corporations mentioning about them, they had to mention whether it is voluntary and they have to mention whether it is exceeding the predetermined cap or not. Then eco-friendly claims have to be validated. As I already mentioned, a certification, a third-party certification, a self-study certification is very much required. Now, let's come to the central authority. The guideline does not have any such nodal authority or central authority. That is one of the lacunas in the current guideline. However, the CCPA has been constituted under the Consumer Protection Act. The CCPA is constituted by Government of India. CCPA comprises of the Chief Commissioner, the commissioners, and then at the state and the district level, the regional officers. The complaint relating to the violations of rights of consumers, unfair trade practices, and misleading advertisement has to be addressed to the CCPA. However, there is a proper hierarchy. The first, it goes to district collector, the regional commissioner, and then the CCPA. Few powers and functions of the authority are also being enumerated in section 18 of the Act. It's displayed on the screen. I will just run you through. To enforce the consumer right and prevent unfair practices, to ensure truthful, non-misleading advertisement, as we already discussed in detail, investigates the violation, files complaint, promote awareness among people, recommend the policies and changes as per the change in the law, as per the requirement of the consumers and the increasing consumer sensitivity, issue safety alerts, and mandates the good identifiers. Further, it advises government and NGOs and work in collaboration with them. It basically, the whole aim is to harmonize the efforts of both the statutory regulatory bodies and the industry stakeholders. Now let's move on to the next slide. Next slide mentions about the other powers and functions of the CCPA. It has the power to investigate and refer to regulators. It can also summon any individual for any record purpose that is required for a proper hearing. Section 20 deals with recalling of any such goods or services that are hazardous and are already out in public there. However, it can also seize those goods upon a proper opportunity and hearing given to both the contesting parties. Section 22 deals with search and seizure. Authorities And officials have been authorized here. They can search the premise, they can seize the item, and upon a proper hearing and as per the disposal rule in the section, they can also allow the disposal of the product or these goods seized. However, anyone who is agreed by the order of the CCPA under section 20 or 21, they have the right to appeal to the National Consumer District Forum within 30 days of the order. Now let's move on to the next slide here. So there are three level of hierarchies here currently under the CPA Act. The guideline again does not have any such nodal authority as I mentioned. So the existing grievance redressal forum is the only forum that is available to the consumers to raise their grievances. It's the district, the state, and the national. The district forum has a pecuniary jurisdiction of claims and of goods and services up to 50 lakhs. Then appeal from district can go to state, and also the pecuniary jurisdiction has increased from 50 lakhs to 2 crores. Then above 2 crores, any claim of goods and services above 2 crore goes to the National Commission, and further any appeal from the State Commission goes to the National Commission. This is a brief background of the existing legal hierarchy. I'll just run you through the penal consequences are also there on the contravention. It's just for information purpose. The Consumer CCPA Act of 2022 also deals with the first time offender penalty, repeated offender penalty, the misleading advertisement penalty, then endorsements that are misleading, though the range is 10 lakh to 50 lakh, and then imprisonment is from 1 year to 3 years. Then the FSSAI Act of 2006 also deals with misleading claims relating to food product. The penalty is up to 10 lakhs. Then the Consumer Protection Act also deals with penalties under section 21, 24, and 89. As I've already discussed, the range is from 10 lakh to 50 lakh, and imprisonment is also there from 2 years to 5 years. Now let's go on to the next slide. As my colleague has already mentioned, that this entire current guideline on greenwashing came into picture because of a very pressing issue that was discussed in this one of the landmark judgments of Patanjali Ayurveda Limited through its managing director Acharya Balakrishna and Ramadev. This matter was given a huge media attention owing to the fact that it dealt with the misleading advertisement. This is not specifically dealing with environmental claim. However, this matter set the wheels in motion to the current guidelines that came into picture. I'll just give you a brief background what led to the filing of the petition before the Supreme Court. Patanjali has actually, during the COVID era, came up with a coronal tablet, and they claim that they have a WHO accreditation to that, and it helps in permanently curing the COVID-19 infection. However, when at a later on stage, it was discovered that the WHO accreditation was not valid. WHO has refuted the claims of Patanjali. Later on, Patanjali has also given out few advertisement defaming the allopathy medicine that they cause side effects. These were not taken in a good way by the allopathy and the IMA, the Indian Medical Association, and they sent a 1,000 crore defamation notice to Patanjali, and later on they moved on to the Supreme Court alleging the misleading advertisement. Because of this case, the stakeholders were quite serious authorities, be it the government of Uttarakhand, the state licensing authority of Uttarakhand, who actually gave the license to Patanjali coronal tablet, and the IMA was also involved. Hence, Supreme Court has came down very heavily on this misleading and deceptive practice of creating illusions in the mind of customers and misleading and exploiting their sensitivity towards a eco-friendly product. Few of the guidelines and the directions that are given by Supreme Court in this matter is of great importance to understand the whole picture that led to this guideline. So broadcasters and print media, they have to submit a self-declaration form before publishing any advertisement, and they have to ensure that the ASI guideline and any the related regulation has to be complied with. In furtherance to this direction, the Ministry of Information and Broadcasting has brought in a regulation in June 2024, wherein self-declaration certificate regulation has been provided, and it has been a mandate now for the digital print media industry stakeholders to provide for the self-declaration certificate. Second, union ministers were also taken into picture in this because of the involvement of state of Uttarakhand and the licensing authority. They have been directed to establish procedure for consumers to lodge complaints and ensure that timely redressal is provided. Now, celebrity and social media influencers were also given a proper mandate here. They have to have sufficient knowledge and experience before endorsing any product, any service, and they have to be held liable for any such misleading claims. Last, Central Consumer Protection Authority has been directed to disclose the actions, whatever they have taken against the false and misleading advertisement, specifically related to the food and health sectors through the Ministry of Consumer Affairs, Food and Public Distribution. Now, let me take you through the very last slide of our presentation. These are few of the lacunas that are being discussed around the industry stakeholders, the legal industry. These are not substantiated lacuna. However, these are just in discussion around there. I'll just run you through them. The very first is the enforceability aspect. It's still in dilemma because none of the statutory authority has provided a enforceability backing to this guideline, and hence the ambiguity there in legal effect is still there. Then the credible evidence gap. The terminology credible and reliable evidence is open to hundreds of interpretation. That has not been dealt in a clear mandate, and it becomes difficult to discharge the burden of proof at a later stage when a consumer or an entity approaches a redressal forum. There's an absence of nodal authority, as I already mentioned during my presentation. The only authority there is a CCPA. However, no specific pinpoint authority is there under these guidelines. The last one, it's a conceptual contradiction, if we can say, like the Consumer Protection Act, that is the parent act. It deals with personal interest of the consumers, be it right and personam. However, the entire object and intent to bring this 2024 guideline was to address the larger interest, that is environmental friendly product, sustainable practice, that is the right in rent. So the contradiction exists there. So there ends a presentation. I thank all the listeners to have such a great patience and listen to our presentation. Now